Have you entered into a contract? Want to know what makes a contract valid? Let me discuss it with you in this video. A contract is a meeting of minds between two persons whereby one binds himself, with respect to the other, to give something or to render some service. The contracting parties may establish such stipulations, clauses, terms and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. The three stages of a contract are preparation or negotiation, its perfection, and finally, its consummation. Negotiation begins when the prospective contracting parties manifest their interest in the contract and ends at the moment of their agreement. There is perfection or birth of the contract when the parties agree upon the essential elements of the contract. The last stage is its consummation, where the parties fulfill or perform the terms agreed upon in the contract. A contract is perfected by mere consent. Consent arises from the moment there is meeting of the offer and the acceptance upon the object and the cause. For example, John offers to sell to Jane a notebook for 10 pesos. Jane agreed to buy the notebook for that price. The contract is already perfected. In order for a contract to be valid, it must have three essential elements. First, the consent of the contracting parties. Second, the object certain, which is the subject matter of the contract. And third, cause of the obligation, which is established. If the parties merely exchange offers and counter-offers, no agreement or contract is perfected between the parties. A qualified acceptance constitutes a counter-offer. For example, instead of accepting John's price of 10 pesos, Jane offered to buy the notebook at 8 pesos. A counter-offer is considered in law a rejection of the original offer and an attempt to end the negotiation between the parties on a different basis. Contracts are valid and binding from their perfection regardless of form, whether they be oral or written. Under Article 1356 of the Civil Code, contracts shall be obligatory, in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. Thank you for watching The Legal Doodler. Be sure to subscribe to our channel, leave a like, share and ring the bell button to be notified about our latest videos. You may also follow our Facebook and Instagram account. See you on our next videos.